Okay, let's start. Good afternoon to you all, and welcome to our roundtable. Ecocide should harm to the environment be criminalized. My name is Christophe, and I'm the acting academic director of the TMC Asser Institute, which is a research center on international and European law here in The Hague, and also one of the proud sponsors of the third International Conference on Environmental Peace Building. And I'd like to take this opportunity also to thank the organizers of this wonderful conference, in particular Carl and Daniela Dambion, for the opportunity to also speak on this important topic. Now, about this topic. Since its early inception in the context of Vietnam War, criminalization of ecocide has met with fluctuating interest from the international community. The contemporary period is undoubtedly one of increased awareness and attention, as demonstrated by the coordinated efforts of certain states to include ecocide in the statute of the International Criminal Court, or ICC. Our roundtable will explore the pros and cons of adding the so-called fifth international crime, so next to genocide, war crimes, crimes against humanity, and the crime of aggression, welcome, in the Rome Statute of the ICC. Moreover, our speakers will address underexplored aspects of criminalizing ecocide, such as the interaction with other branches of international law, interaction between the domestic and international legal orders, as well as the ICC's reparation framework and its capacity to provide reparation for the crime of ecocide, if it's going to be included one day in the Rome Statute. And moreover, we'll be able to provide a sneak preview of the book with a somewhat similar title that four of us have been editing, and that is forthcoming with the TMC Asser Press and Springer Verlag. I'm thrilled that we have four excellent panelists who are willing to share their wisdom with us on these matters. And I will now introduce you to them. So our first speaker will be Dr. Lara Burgers. She works as an assistant professor at the Amsterdam Center for Transformative Private Law, or ACT, at the University of Amsterdam Private Law Department. Her research interests include climate change litigation, democratic theory, rights of future generations, and rights of nature. She is one of the experts in the UN program Harmony with Nature on the Rights of Nature, and Burgers joined ACT's predecessor, the European Center for the Study of European Contract Law, as a PhD candidate in 2016. And in 2020, she defended her PhD thesis entitled Justitia, the People's Power and Mother Earth, Democratic Legitimacy of Judicial Lawmaking in European Private Law Cases on Climate Change. And Burgers has studied at the University of Amsterdam, Sorbonne, and NYU. Our second speaker will be Merle Kooijman. She works as a PhD fellow at the Amsterdam Center for Criminal Justice at the University of Amsterdam Criminal Law section. She works on a dissertation on the philosophical foundations of an international crime of ecocide, supervised by Professor Jon Slijter, Professor Sergei Vasiliev, and Dr. Lara Burgers. Her research interests include critical legal theory, international criminal law, also criminal law theory, environmental philosophy, and post-humanist philosophy. Kooijman teaches criminal law courses in the bachelor and master programs, and she graduated from Utrecht University, Bachelor of Law, and Bachelor of Arts in Philosophy, and the University of Amsterdam, Research Master in Philosophy, and a Master in Criminal Law, cum laude. And for her PhD research, she stayed for 3 months at the Hebrew University of Jerusalem in 2023. Our third speaker will be Dr. Stavros Pantazopoulos, and he is an associate fellow at the TMC Asser Institute and a visiting researcher with the Toxic Crime Project at the University of Helsinki. He's also a senior research fellow at the Hellenic Foundation for European and Foreign Policy and a member of the World Commission on Environmental Law. And he was among the founding members of the Environmental Peace Building Association and currently also serves as the chair of its law interest group. And Dr. Pantazopoulos teaches international law at the law school at the University of Athens, and his research focuses on the legal aspects of environmental protection during and after armed conflicts. And last but not least, our fourth speaker, Dr. Niki Siampakou. She is a joint research fellow at the International Center for Counter-terrorism, also based here in The Hague, and the TMC Asser Institute, working on victims of terrorism and transitional justice approaches to counterterrorism. Prior to her current position, Dr. Siampakou worked in the field of transitional justice as a research and training project manager at the Institut Joannin in France. She also participated in 2 field missions in the Central African Republic and in several conferences. And between 2016 and 2019, she was a contractual researcher at Aix-Marseille University. Dr. Siampakou holds a PhD in international criminal law from Aix-Marseille University, and her doctoral dissertation entitled Against All Hopes, the Untenable Promise of Reparations at the International Criminal Court, which may already say a bit about what you will be saying later, provides a critical analysis of the ICC's preparation mandate. And during her PhD, she was a visiting scholar also at NYU and at the University Amsterdam. So thanks to all of you for your willingness to contribute to this roundtable, and as agreed, and for ease of communication, we'll continue the panel on a first name basis. About the structure of this roundtable, I will first ask the speakers to provide brief presentations, after which I will each ask them a question before we turn to you and the audience for any questions that you may have. Maybe let's start with the presentation, setting the scene a bit. And I would first like to give the floor to Laura, who will say a bit more about our forthcoming Ecocide book, with, as explained, a somewhat similar title to contextualize the topic of criminalizing ecocide and also present the sort of questions that this topic evokes.
Thank you very much, Christophe. This morning, I opened my window and I saw the sun. I live actually close by. I live here in the Netherlands, and it was also peaceful and silent. And I was enjoying the silence for a while, and then it dawned upon me. We are in a silent spring. Of course, it's actually the first day of summer, but I hope you forgive me that. No, I thought about this book entitled Silent Spring, published in 1962 by Rachel Carson, in which he describes, or in which he alarms about the usage of pesticides and says, eventually, spring is going to be silent. And of course, there are still some birds, but I do think that our spring is now actually as good as silent, and that we have silenced the birds by not providing them with enough food because we have used so much insecticides. And this is also confirmed by biodiversity research. So the WWF Living Planet report says that now animal populations have decreased something like 70% since the 1970s. And always when I hear that statistic and when I process it, I think to myself, yeah, that is ecocide. That is ecocide, this mass, I'm not sure if we should use the word murder, but in any event, if we would think of a human population that would have decreased that much, we probably would immediately say that that's genocide. And this notion of ecocide, this genocide on ecosystems, is in a way, I think, so intuitive. And yeah, that's one of the reasons why I'm actually grateful that we are working on this book together on this topic. So what I will do is to tell you some about the background of this book that we're working on about ecocide. I'll tell you something about the substance, and I'll finish up with one or two questions that I think are interesting, perhaps also to exchange thoughts about with you. So as many of you may know, the Stop Ecocide Foundation has brought together a panel of experts who drafted a definition of ecocide, and they finished doing this in June 2021. And this was the start of a whole academic debate on this definition. I mean, of course, the debate about ecocide was going on for already a longer time, but this was really creating a sort of momentum. And this was also true at our academic homes. So Merle and I, we decided to host a workshop to discuss the implications of this draft definition. And that's, to be clear, not yet formalized or recognized as law in any sense, but it's really just a sort of suggestion by this very authoritative panel. And more or less at the same time, Christophe, you also hosted a workshop actually for the same purpose at the Asser Institute. So we decided to join forces and later on to actually make a book out of this. So that is going to the book that you mentioned, and that will be published. So that's a little bit about the background. I will now say something about the substance of that book. So we organized this book into 4 questions. What is ecocide? How should it be prosecuted? Where can that be done? And who are the victims and who are the perpetrators of ecocide? And obviously there are many more questions that one can ask about this fascinating concept, But these are the sort of main questions that we seek to address in this book. So in the What is Ecocide section, there is a contribution by one of our authors really delving into this debate about how ecocentric or anthropocentric the law is, how much it is focused on human beings, and to what extent ecocide can perhaps address that. In the How Should Ecocide Be Prosecuted section, there is a chapter addressing whether large-scale environmental harm can already be addressed under existing international criminal law. And there's another chapter which argues that if ecocide were to be criminalized, this should be a so-called autonomous crime. And I know that there's not only lawyers in the room, so I'll explain it a little bit. So in administrative law, usually one can only, something can only be forbidden if that's already expressly the case. So, or only if you did not act in accordance with some kind of administrative authorization, then there's usually a crime. But these authors suggest that we should disentangle that administrative law from criminal law, so that even if one had the administrative authorization to, for instance, use a certain pesticide, then still potentially there could be a crime. In that How section, there's also a chapter on the relations between, on the one hand, ecocide, and on the other, all kinds of human rights. Because I think many of you may also know that human rights over the last, let's say, decade or so are increasingly interpreted to also cover all kinds of environmental issues. So there's an increasing recognition that there is something like a human right to the environment, but also rights like the right to life or the right to a private life are increasingly interpreted as covering environmental issues. So this chapter there seeks the parallels between those developments and ecocide. So that's about the How section of the book. We also have this Where section of the book. Where should it be prosecuted? Because this panel that I mentioned proposed a definition to be included in the Rome Statute, which is the treaty that establishes the International Criminal Court. But actually, in quite a number of countries on a national level, ecocide has already been recognized. So, for instance, this is the case in Ukraine, and we have a fascinating chapter in the book about this Ukrainian ecocide law. And we have a chapter of two Dutch scholars who argue that the Dutch public prosecutor should also do more against ecocide. That's about the Where section of the book. Then the last section of the book addresses this question: who are the victims and who are the perpetrators of a crime of ecocide? And one chapter delves into the difficult question of how we can find actually a perpetrator of a crime if we were to speak about climate change. Because climate change, of course, in a way, we all cause climate change. I mean, everyone here definitely in this room does it. By travel, consumptions, etc. So what is the relation between producers and consumers there? This author seeks to explore. And ultimately that leads him actually to the conclusion that perhaps climate change is an issue that is too complicated to be covered under the heading of ecocide. Another chapter looks more into that perpetrator dimension of ecocide, asking whether you can aid and abet to ecocide, for instance. A bit legal technical, but a very important question to address if you actually want to formalize a crime of ecocide. And the last chapter of the book delves into the question whether the environment can be a victim of ecocide. And this author is arguing that yes, indeed, already under existing law, existing international criminal law, we could actually qualify the environment as a victim. So that's in a nutshell our book. Of course, I can't do it justice here, summarizing all these chapters in 1 or 2 sentences. But I do think that that all this shows that there are particularly relevant questions to answer. So one of perhaps, in my view, the most pressing issues is whether we should want to capture climate change under this header of ecocide. Merle is actually the expert, as Christophe explained, on ecocide, and I also understood from you, Merle, that a lot of people in the ecocide debate focus very much on climate change. Whereas I think personally that this whole issue of biodiversity, with which I also started, is way more intuitive to fit under this this concept of ecocide. Another issue, of course, that is important, and I'm particularly interested in that because I'm not actually a public lawyer, I'm a private lawyer, is the threshold. Like, when is the damage widespread or of a scale large enough to qualify as ecocide? And I'm interested in that because I'm researching in my capacity as a private lawyer also the rights of nature, and I'm very interested in this also private dimension of the rights of nature, where of course even if only one tree is harmed, that can perhaps already be a violation of a right of that tree. Whereas for ecocide, I mean, also one human rights violation, of course, is not immediately an international crime. So that threshold issue, I think, is very interesting also to explore. Well, and I can go on and on, but I think maybe already past my 7 minutes. So thank you very much. And I should give the floor now to Merle, right?
And the mic.
Yes, and the microphone.
Good afternoon, everyone. Is it run? Just a small heads up before we start. I lost my glasses last Sunday after a football match, and so I cannot tell by your face whether you're intrigued or annoyed. If you have a question, just please raise your hand, because I can't tell by looking at your face. Can everyone hear me correctly? Perfect. So, over the last decade, the campaign to criminalize ecocide has gained unprecedented support from states, regional and international bodies, academics and activists. There is apparent consensus amongst its proponents that a crime is needed that adequately reflects the environmental crises of our time. A lot is thus expected from a crime on ecocide. The discussion about its criminalization is, however, not new. Throughout history, environmental damage that is to be addressed has always been serious, but it now not only primarily covers environmental damage during wartime, but also environmental damage like climate change in peacetime. This is also reflected in the international or in the definition by the International Independent Expert Panel from 2021 that Laura already addressed. And in this talk, I suggest that we should take a step back and to carefully consider why we want to use criminal law to address large-scale environmental harm and what the difficulties are of actually translating environmental concerns in peacetime into international criminal law as a discipline. Since a potential legal response in ICL to large-scale environmental damage or ecocide is evidently directed by what is understood to be constitute the plight of the environment, it is pivotal that we actually understand this plight. This is what I argue in my dissertation on the philosophical underpinnings of an international crime of ecocide. I developed a theoretical framework to assess this plight by engaging with two disciplines, namely green criminology and environmental ethics of care, to establish what is it, who commits it, and why is it actually morally problematic to cause environmental damage. Today, we focus on just one section of this theoretical framework, namely the green criminological assessment of environmental harm. Due to time constraints, I will only highlight some of the preliminary findings when diagnosing environmental damage with the help of green criminology. And I explain how these findings tie into the discipline of ICL, more specifically the Rome Statute, in terms of compatibility. So as leading green criminologist Rob White shows, much of the most serious environmental damage, like for example climate change, is caused by a group of perpetrators. And this often takes place on a legal basis. And this legal-illegal binary concerning environmental crime is regularly reflected by a tipping point. Activities are condoned and they only become illegal once a certain boundary has been crossed. And this tipping point of illegality contrasts environmental crimes with other criminal offenses, such as the current core crimes in the Rome Statute. Moreover, the reality of environmental harm is that people rarely act with the intention of actually harming the environment. Rather, it's a consequence or a byproduct of a pursuit of other goals, like monetary gains. Conceptual consistency with the Rome Statute is thus missing when it comes to by whom ecocide in most cases is being committed, as well as the intention behind the act. Thus, unlike the other core crimes in the Rome Statute, much severe, widespread, and long-term environmental damage, such as climate change, is caused in the daily normalized interaction of supply and demand in a capitalist society that is, as said, often lawful or legal. But the Rome Statute as it stands does not include corporate accountability. The focus is rather on individual accountability. Also, following Article 30 of the Rome Statute, intent needs to be established as the mens rea element. So one needs to intend to commit environmental damage before one can be considered guilty of creating environmental damage or ecocide. In my dissertation, I describe environmental damage as a time and space lagging phenomenon. So much environmental damage, like climate change, evolves over a longer period of time, as emissions of GHGs stay in the atmosphere for decades and even longer. And the changes they cause in our environment are gradual in nature. In contrast to other crimes, climate crimes are consequential in nature and have an indirect effect, both in the sense they affect human and non-human communities and people across the globe, irrespective of the place where the crimes were allegedly committed, and because there is often a major time interval between the alleged acts and their consequences, since it may take a very long period of time before the effects of a certain act are actually evident. These unique features pose substantial challenges with regard to the element of mens rea, as well as other specific offense requirements, such as causality. Also, conceptual consistency could be considered lacking in relation to the current core crimes, since questions regarding temporal jurisdiction may be simply resolved or more simply resolved with the current core crimes, because the harm likely occurred at or around the same time as the offense. The core crimes in the Rome Statute were tailored and therefore are far more suited to the prosecutions of actions that take place in a specific time frame at a particular location on the globe, and that follow a more simple pattern or causal chain. Then I also briefly consider environmental victimhood. Green criminology studies show that environmental harms affect human and non-human life, ecosystems, and the biosphere. Environmental damage can therefore be considered from a non-anthropocentric perspective, since its focus is not only on human suffering from environmental damage, but also on environmental victims per se. ICL, on the other hand, is entrenched in anthropocentrism, as follows from previous work of mine, in which I showed how humanity as a central concern came about by looking at two conditions of ICL specifically, namely the notion of the ideal victim and the international community. So first, the international community. ICL has its basis in the idea that there is an international community which is a moral community. This is based on the idea that there are some values which we all share universally. In the literature, this international community is a community of humans only, and it serves as a construct which is a moral ideal. As such, it legitimizes ICL as a project. The coming of age of the central concern can be described in tandem with the rise of the international human rights paradigm in international law. Moreover, the current core crimes in the Rome Statute have acquired some kind of elevated status and are considered to be serious human rights violations. It could be argued that this frame obscures or marginalizes other injustices, because ICL as a discourse actually produces some damages, namely damage to the environment, as non-existent. The representation of the other in ICL is actually a useful or necessary tool to legitimize ICL as a project. Hence, humanity as a universal productive interest seems interwoven with the normative underpinnings of ICL. Then I explored the ideal victim as an enabling condition of ICL's anthropocentric focus. This was inspired by Sobha Patel's neoliberal contextualization of victimhood in ICL. She describes the ideal victim in international criminal law as these non-white, vulnerable women and children. This ideal victim is turned into a spectacle because of what she describes as the attention economy. Attention as a scarce and valuable good. Now I'm lost. Yeah. By making a spectacle out of victimhood, the International Criminal Justice Project not only legitimizes its presence, but it also structures discourse. It orders by introducing hierarchies on what is worthy of attention. Environmental harm, especially in peacetime, is not recognizable in ICL as it stands, and this could be partly explained against the background of the interest in particular human victims. Thank you.
Much. Stavros? Ah, okay.
Yeah.
Yeah, maybe we can test it a bit if we put it in the middle-ish.
Is it working right now? Let's see.
That is definitely working.
It's definitely working. Okay, nice. So I will elaborate my thoughts on the need to portray and to understand the interaction between legal orders so as to deduce an appropriate definition of the crime of ecocide. This builds on my work with another colleague of mine, Martina Papadaki. So I want to also give credit and recognition to her work. Now moving to substance, my main claim today is that we need to understand the main underpinnings, the normative underpinnings, and especially the interaction between various between various legal orders within international law. So this is what I claim an intradisciplinary exercise that is much needed. The three main fields of law of international law I have in mind, of course, is international humanitarian law, international criminal law, and international environmental law. This is the first axis of my analysis. The second corollary claim is that we also need to comprehend the interaction between the domestic and the international legal orders. Of course, we are familiar with ideas of monism or dualism, but I will argue that these are not sufficient for the purposes of this exercise of defining and criminalizing ecocide. Let me start with the interaction of these three legal orders: IHL, International Humanitarian Law; IEL, International Environmental Law; and International Criminal Law, ICL. First, I argue that we need to agree and, of course, to reach a common understanding on the good norms, the guiding, the overarching principles that guide these three fields of law. So the mainstream understanding that IHL, the laws of war, as we another term we use to connote this field of international law, is of course to reduce human suffering in the context of hostilities. ICL, of course, we also see it in the preamble of the Rome Statute that was mentioned before, the International Criminal Court Statute, is the fight against impunity. And IEL, International Environmental Law, the mantra, the common mantra there is, of course, the pursuit of sustainable development. As opaque as this term may be and sound, especially when it comes to its legal status, this is, I argue, the main objective that could summarize the goals of international environmental law as it stands today. Building on this assumption, I argue that the main question here is how to find a meaningful way, a point of intersection between these three fields of law and of international law. And in my survey, in our survey, I've reached the conclusion that it's a very difficult exercise, and it seems that at points we tend to prioritize one over the other, which is fine. It is fine as long as we are aware of the choices we make, and of course the consequences of these choices. They might translate in informed litigation, which form will be the appropriate one, and prioritization of needs, and policies, etc. It could also go, to the level of reparation as well for mass environmental harm. So, if we have a look at how IHL deals with environmental harm, we will see that there are a couple of environment-specific provisions in the applicable legal documents, in the additional Protocol 1 of the 4 Geneva Conventions. And there we see that the main environment-specific provision establishes a very high threshold of the prescribed environmental damage that is widespread, long-term, and severe. I won't go into the details how to interpret this. The main point here is that the threshold is very high, and this has been done by design. They knew that this it would be a very difficult threshold to reach. So this is how IHL deals with environment harm, establishing a very high threshold, and of course, in the context of interstate wars, as the term of art would go, in the context of international armed conflicts. Moving to ICL, International Criminal Law, and I see this for the purpose of this survey as neighboring frameworks. ICL, again, of course, draws on the wording and on the understanding of international humanitarian law. So in the Rome Statute, in the Statute of the International Criminal Court, we can identify a war crime applicable, again, in interstate wars, in international armed conflicts, which is environment specific. It draws explicitly on the language, the provision I mentioned before, the high threshold of prohibited environmental harm, and in addition, it adds a balancing exercise, a proportionality test. So on the one hand, you have to weigh this very high threshold of environmental harm, damage to natural environment, as the term would go, and on the other hand, you have to weigh this against the military advantage anticipated. The latter part, of course, is nowhere to be found in IHL. This is the addition of ICL in order to find impunity. Again, repeating the group note under international criminal law. We see, of course, that the focus also here, as I mentioned before, it is a war crime. It can only be committed, perpetrated in the context of an armed conflict. This is by definition. It cannot be omitted. Moving to IEL, International Environmental Law, and having in mind this overarching principle of sustainable development, and having a look at the definition of the independent expert panel that was mentioned before by my colleagues, at some part of the definition and the associated commentary, we see that the expert panel introduces a balancing exercise between mass environmental harm on the one hand, of course, and on the other hand, the social benefits anticipated. So you have to weigh one against the other. This relates to the definition of the term wanton, as it can be found in the in this definition in the associated commentary. The point here, of course, is that we have altogether different balancing exercise, which makes total sense. Of course, we are now mostly in peacetime, even though the definition of the independent expert panel does not say anything about wartime in the sense of excluding these offenses, this case. But in my mind, at least in my the way I read it, I see that it's mostly designed for times of peacetime, which makes total sense. Again, there was a discussion before on another panel how Ecocide connects to wartime conduct, etc. And it's interesting also to trace the trajectory of this term. Of course, in the beginning, as it was coined and the definition given by Rachel Falk, back then having in mind the conduct of US troops in the Vietnam War, it was a military-related definition. This is how it emerged. I'm curious to see, if we have a quick sample here, a quick survey, how we would conceive ecocide nowadays. Would it be mass environmental harm, also perhaps in the context of climate change, as we mentioned before, or the first point we would go, our mind would go immediately, would be wartime conduct. I think this is an interesting inquiry, how the term has obtained its own autonomous, independent path in life. So this is about the interaction of these legal orders. Of course, in international law, we have different devices and tools to deal with this. One common framework is that of fragmentation. And another one is the idea of pluralism, the idea of pluralism, drawing elements from different various legal orders or branches of international law could enrich the interpretative exercise. I'm afraid, though, that for this exercise, defining and criminalizing ecocide, these two legal vehicles, legal tools, are insufficient. Because for this one, we are talking about norm creation, something that will spring out, not necessarily of nothing. Of course, we do have domestic laws criminalizing ecocide. But again, it's about norm creation. It's not about norm conflict or anything like this. So these tools we're familiar with usually concern non-conflict avoidance techniques, for example, or harmonization of conflicts that may occur when more than one laws or legal regimes apply. So in my view, these devices are insufficient by definition, by necessity. This is the first claim, and that's why I argue that we need to do more conceptual work. And of course, Merle's work perfectly fits with this understanding how compatible the ICL and ICC statute is for the purposes of this exercise, and I'm sure we'll get back to this question later on. My last point, because I guess I'm running out of time, is about the interaction between the international and domestic legal orders. The main principle on the basis of which we operate in international criminal law is the idea of complementarity, of course, as it is enshrined in the International Criminal Court Statute. In essence, in a nutshell, it says that first go to domestic courts, domestic laws should be given priority, and then we have the fallback option, the default option, which is international criminal court, but of course it prioritizes domestic prosecutions. And here, as we mentioned many times during the conference, we do have definitions and domestic laws. Ukrainian, of course, will keep coming, rightly so. Definition of ecocide and of course prosecutions, cases that have already been initiated, but of course this point raises the complex question of how these definitions will interact, the domestic one with the international one, if we ever manage to agree on an amendment perhaps to the ICC statute or to a self-standing convention. The principle of complementarity could help us in this respect, but it could not carry the day fully because there are divergences. And again, if we have a look in domestic definitions, we will see again that the focus is on mass environmental harm, and rightly so. At least this is what I argue, this is how I conceive ecocide, and not necessarily on wartime conduct. Of course, it could also be applicable therein, but the primary focus is not to that. The starting point is mass environmental harm. So we have to figure out also how to deal with wartime conduct. And this, I think, is this point is highlighted through the interaction between the internationally suggested definition and domestic definitions we already have in place, and that they are already being operationalized. And I think for the moment, I will keep it to that.
Preparations in the ICC.
Good afternoon, everyone. Thanks, Christophe, for giving some hints about the topic. My presentation would focus on ICC's ability to order reparation for the crime of ecocide if one day these crimes falls under the jurisdiction of the court, claiming that the ICC has a certain legal framework to provide this reparation, as I'm gonna present first of all the framework that exists in the ICC and later see a little bit the form that this reparation will take. So the ICC, as widely known, is the first international criminal court with a reparation mandate. This reparation mandate is based on Article 75, according to which reparations are awarded by the ICC's trial chambers following the conviction of an accused, and they can take different forms. This is the following 5 forms: restitution, compensation, rehabilitation, which are mentioned inside the article, but also satisfaction and guarantees of non-repetition, which is the other 2 forms of reparation, and they have been indeed ordered by the court. This reparation is linked to individual responsibility, and this is a big limitation of the court, to specific charges and award to recognize victims of the crimes for which the defendant was convicted. Reparation can be made either by the convicted person directly or where appropriate through the Trust Fund for Victims. The Trust Fund for Victims is an independent, non-judicial institution which can use funds made available to it through voluntary contribution, which are made by states. They can also be made by individual and international and national organizations. But if we see until this moment, it's the states that gives these funds to the Trust Fund for Victims. These funds can complement any money or property collected from the convicted person, or can be the only funding for the reparation. And as we can see until today, given that all the convicted persons from the court have been declared indigent, it's these funds from the Trust Fund for Victims that are funds all the different forms of reparation. The reparative measures that they are ordered by the court can be individual, can be collective, or both, and can include, as I say, 5 different forms. The necessary condition for a victim to claim reparation is to be a natural person, but it can also be a legal entity, as the Rule 85 of the Procedure of Evidence of the Court recognized as victims' organizations that have a certain mandate. The victim should have a harm which is direct or indirect, but it should be personal and can be material, physical, and psychological. Reparation can be awarded if the harm suffered was a result of the commission of any crime within the jurisdiction of the court, and the causal link between the crime and harm can be determined in light of the specificity of the case. So this is the legal framework of the court in a really brief way. But what can reparation look like in the case of ecocide? So if someone is convicted for the crime of ecocide, the ICC has 5 different measures of reparation that can be ordered. First of all, the court could order restitution, which is known that it's the reparation par excellence, because it's aiming at restoring the victim to the original situation that it was before the violation. So in the case of ecocide, this can include, for example, orders for restoration of any harm to the environment caused by the commission of the offense, or it can also cover payment to an environmental organization, which could be after implement a restoration project. A second form of reparation, as I mentioned, can be the compensation, and it's the widely, the most frequent form of reparation that is ordered by courts. And this refers to economical assessable damage. And in the case of the ICC and the crime of ecocide, of course, it would present certain difficulties, which be, for instance, expert testimonies, site visits, appropriate evidence collection, and of course, the adequate funding, as it's one of the most financially expensive measure of reparation. But considering compensation, we can see, for instance, the jurisprudence of the Inter-American Court of Human Rights, which has already ordered reparation as a form of compensation, as a form of reparation to indigenous communities for the loss of culturally significant land and natural resources. And this compensation was included material damage as well as immaterial damage. So the ICC has certain jurisprudence to look regarding the measure of compensation. There is also the form of rehabilitation, and this can include the creation of community development funds. It can also include access to clean water and food security, access to psychosocial rehabilitation, because ecocide can also have an impact on victims' life plans, their cultural and community and family life, and social interaction. And these psychosocial measures can include, for instance, psychological support, social services, and community counseling. And reparation can also have symbolic value, and then we are talking about the measures of satisfaction, which in the case of ecocide, it can include initiatives for commemorative events. It can also include the establishment of a memorial or public excuses by the convicted person. And finally, there is the measure of guarantees of non-repetition, which is a 5th form of reparation, and its main goal is to contribute to the prevention of this crime. So there we can talk about legislative reforms for better protection of the environment. We have also the possibility of regulation that ensure maintenance of the environment. And we can see that the ICC has already ordered guarantees of non-repetition in the case of Almaty, which concerned the destruction of cultural heritage. And the main issue about these guarantees of non-repetition is that we need the collaboration of the state. And again, the ICC addressed only individual responsibility. All these forms of reparation, if they are ever ordered by the ICC, should of course have what we call today transformative nature, which means that this reparation should contribute to overcoming structural inequalities and not perpetuate stereotypes and patterns that they existed before the commission of the crime. So in conclusion, if Ecocide is included in the jurisdiction of the court, ICC can order individual, collective, or both reparation to victims, which can take 5 different forms. Other jurisdictions, in particular, the Inter-American Court of Human Rights, that deal with a lot of cases concerning indigenous communities, can be a source of inspiration for the court, but also its own jurisprudence, especially the case of the Almaty, which has demonstrated that the court can indeed think creatively and find solutions for this kind of offenses. Nonetheless, there is a series of challenges and limitations in the court's possibility for the reparation, which I would like to see further during the Q&A, because I'm afraid that the time is running. So thank you very much.
Yeah, thank you very much for all your insights. I think really touching upon so many relevant aspects of the Ecocide topic. Now, I promised at the very beginning that I would now abuse my position as chair to ask the first round of questions. But it's always difficult to respect the time allocated to you, and we also started a bit later. Moreover, we have promised the organizers to at least reserve 30 minutes for the Q&A with the audience, and we have to be out of this room at 3 o'clock. So this is all to say that we'll now immediately go to the Q&A with you, with the audience. I don't know if there's a hand mic. I'm looking at the organizer. I see a hand, but I'm not sure whether we have a mic in the room.
Simone?
Simone, do we have a mic for the audience?
No,
We can repeat the question.
Sure, we can. Yeah, it's also for the people in line that they can hear, but we'll try to repeat.
Yeah.
And please state your name and affiliation and to whom you are addressing the question. So maybe first.
Great. Well, thanks to all the panelists. Very, very thought-provoking presentations. I think so it seems that we are kind of like maybe in agreement that things are really happening at the national level more than the ICC currently. So I'm kind of wondering if the argument we often hear about the importance of ICC to criminalize at the ICC level is some kind of drop-down effect to national systems, but that's maybe already happening. What really then is the importance of having Ecocide criminalized at ICC level? And everyone seems to speak about the symbolic importance, but where do you see that symbolic importance more specifically?
Yeah.
So a question to all of you, basically.
Thank you. Good question. I will repeat my way. I always forget if we collect a few questions. So what is indeed the relevancy of criminalizing Ecocide at the international level, at